I'm going to ask it in a practical business owner kind of way, and you may not be able to answer this. Let's say you were a solo practitioner; it was your firm, okay? And let's
hmm
say you had to pay $400 or $500 a month for what they call the Westlaw Classic now,
hmm
and they said, "All right, Mr. Caldwell, you can have the AI search for let's say $1,000. Would you pay the extra $500 a month for it?"
Absolutely not.
Welcome to episode 92 of the Weekly Docket, a podcast by the Silberman Law Firm. Today is October 16th, 2025, and like we usually do, we're going to talk about practical law and answer some legal questions. I'm Phil Silberman, owner of the firm and your host, and I'm joined by Patrick Caldwell, who's sitting in for Chris Heald today. Patrick's one of the attorneys at the firm. And Patrick, good to have you.
Glad to be here.
Tell us a little bit about yourself. You've got a pretty cool background. Understand you kind of are a Navy guy, and then you got into the law. Tell us a little bit about that.
Well, I went to the Naval Academy for undergraduate, so that was a pretty amazing experience. And afterwards, I wanted to live in Japan, so I picked a ship out of Japan. And unfortunately, I didn't live in Japan. I lived off the coast of Japan for my entire tour. So when I got out of law school, I was looking for other opportunities. And after clerking and going to big law and coming out on my own, I saw an opportunity to work for a Japanese law firm in Japan. And normally, as you know, law is restricted to a geographical or jurisdictional area. So it's unusual for people to be able to just zip around the world. You kind of have to stay where you're licensed. But this company, they were looking for patent attorneys, U.S. patent attorneys, to practice physically in Japan where the clients were, and then file in the U.S. Patent Office, which you needed to be a licensed U.S. attorney for. So I got a chance to do that. I lived there for 6, 7 years, and it was amazing, just absolutely incredible.
How
You can see Japan.
how was the language? I mean, how did you speak the language, or I mean, how did that
I
work?
did. I got really close to fluent, and then as soon as you come back to Texas, especially, everything is in English and Spanish. And every time I heard a Spanish word, I would lose a Japanese word, and so it was a real struggle to keep it up. But
So
I got really close, and
yeah, what kind of law did you do in Japan? I mean, what was your practice area?
well, they asked me mostly to do patent law, so I would be evaluating things for U.S. patent law. There's additionally a lot of M&A that goes on over
Mm,
there where it's kind of regulatory, but I didn't do any of that kind of stuff. I did some trademarks, some copyright questions.
mm,
They also asked a lot of general purpose. Um, what is it like, or what are these laws kind of like? Uh, that sort of thing, kind of a
mm.
comparative analysis. But a lot of that was just more for cultural exchange. The
Okay.
actual work product they wanted was all freedom to operate. Are we infringing? Are we not infringing? That kind of thing.
Mm. Okay. So, and I mean, I want to point out because this is also you're a pretty educated guy. You've got an econ degree, I think from SMU, is
hmm
that right? And then also
That's right. Yeah.
a law degree. And then you were or are working on a computer engineering degree, right?
That's right. Yeah. Well, yeah, that's kind of a long story, but the economics degree I picked up, they were having a special at SMU where you could get your JD and an MA at the same time. So I did that, and it was really a nice fit. I'd studied a little bit of economics and law, which is a big Richard Posner thing, before even going to law school, and there's a lot of interesting overlap there between the two fields.
Mm.
It's a little bit kind of, there's other things that are more exciting to the law talkers now, but for me, it was a nice fit. There was just enough math to make it rigorous, but not so much math to make it a hard science. So it was the right mix.
Well, people underestimate the rigor of the econ degree, but that is neat that you were able to get the econ and the JD. So, very,
Yeah,
very
it
cool.
was fun. It was fun.
So now you're over here with our firm, with the Silberman Law Firm. How in our practice areas, probate, real estate, and business. How are you liking the practice areas?
I love it. I was really surprised at how much fun it has turned out to be. Um, this is dealing with the patent side of things. A lot of it is very technical. I'm helping businesses, and sometimes it's not always kind of a personal connection so much as just a throughput kind of problem. But I have, in the first couple of weeks that I was even here, I was talking to actual people with problems where I might be the only one they talk to in weeks
Hmm.
that will actually listen to what they're saying and not try to brush them off or tell them they're crazy or anything like that. And in cases even where we can't do legal work for them, we can still be helpful to them by just listening and taking them seriously for a little bit. And that was surprisingly satisfying. It
Yeah.
was really great to be able to do real. I think this is kind of what people imagine when they go to law school, being able to actually help folks.
Yeah.
It feels a little bit more like being like a country lawyer, maybe like a family physician kind of thing.
Right.
People come in, they're sick, patch them up a little bit, and send them on their way. It's really it's really satisfying work.
Well, good. I'm glad to hear you say that. We do help real people, small business owners, individuals, and they call us with real problems, and
Mhm.
we solve them. I mean, we're professional problem solvers. That's kind of what
Yeah,
we do. I'm a big believer in helping people and charging reasonable rates for it. So, and
yeah,
it is satisfying. I mean, it really is. Sometimes if you're practicing big corporate law, you can get a little bit lost in the bureaucracy of that, and it not you're not having connection with people. But we are very much a people practice with probate and small
mhm,
business owners and people buying real estate, and that's just part of what we do. It's a big part of what we do. So, well, thank
yeah.
you for coming on the show, and
You're welcome.
we're gonna talk about what we're doing today. So what's this is our kind of our what we call our docket call. The show's the weekly docket, and today we're going to talk about some legal questions, answer some legal questions. Most of these came up within the firm space recently. We had somebody ask whether you have to include a driver's license number when probating a will on an application. And then we're going to talk
Mhm,
about receivers and what role they have in judgment collection. So how to collect judgments and when receivers get appointed and how that works. And then finally, if you're researching a property and you want to know whether it's been foreclosed on, how do you tell whether a property's been foreclosed on? And then in our rant and rave section, which is always my favorite part of the show, we're going to be doing a little discussion of AI. And are these Google AI overviews, are they really accurate when you drill down and you put human eyes on the sources? Is the AI overview giving you the accurate picture? We'll talk a little bit about our experiences and how accurate the AI has been in general, at least in our practice and how we use it. So let's go ahead and get it kicked off with our first section. We're just writing our legal question section. Do you have to include a driver's license number on the application to probate will if you're the applicant? So, Patrick, have you probated any wills yet for the firm?
I have started them, yes. I have never, yet finished one. I've still got a lot of them that are sort of in the prep phase, but,
Yeah.
this is part of it is learning that, there's elements of these forms that you have to know which parts are crucial and which parts are, sort of maybe optional based on where it is that you're gonna probate.
Yeah. And that's a good point because in the practice of law, that can actually be different. What happens in practice can be different than what the code calls for or what the forms are giving
Mhm,
you. And this is a perfect example because if you go to the estates code, it's section 256.052 1-A, it will tell you when you're probating a will and you do an application, it wants you as part of a requirement to that application include the driver's license number and the social security number if the applicant has been issued one. Now,
mhm.
I'll tell you in practice, I don't know how often that really happens, right? Because people don't want to put their personally identifiable information on there. Since you said you've started some applications, have you included them, or have the clients been willing to do that, or have you just kind of skipped over it? What have you done?
Well, what's interesting to me is that people are very used to giving out the last 4
Hmm.
of their Social Security number and the entire driver's license number. So, I'm a bit of a sort of a privacy, enthusiast, let's say, and, I don't like to give out any of these numbers, but here they're only asking for the last 3, And sometimes when I do have to ask the clients for them, they will give me the last four and they say, "Oh yeah, never mind. Just the last three are blah, blah,
Mm,
blah." And I thought that was kind of interesting. And when they are telling me this,
mm.
they have to recite their entire driver's license number to get to the last three,
Yeah,
which
that's
and I can sometimes if I I can see them counting in their head and then they just
yeah.
verbalize the last three numbers. It's very interesting.
Yeah, well, that's like if I'm counting things, I still pull out the fingers, 1, 2, 3. Yeah. So,
Right.
um, well, look, this question was really kind of more talking about the driver's license number of a decedent, and there are some applications in probate where they may be required as well, but nobody had it. And in
Mhm.
practice, there may not be a lot of the courts may not give you a hard time. So, and in probate, especially if it's uncontested and nobody's fighting you, it often these things just slide through. You being a privacy guy, definitely pointing out it's just the last three with the name. I don't know if you put that in the public records, if bad guys and criminals can do much with that or not, but in this case, we didn't have the decedent, and you just kind of file the application, and the judges usually aren't giving you a hard time. But in practice, what the code is calling for can be very different than what the judge is actually going to take you to task on. So,
Right. Well, and I think one of the things that people, especially maybe newer attorneys, will get wrapped up on is that there is a very generous amendment policy as well. And so the courts are really looking for the administration of justice and not nitpicking bureaucracy, sort
yeah,
of. So if you don't, if the judge actually wants it, they'll usually tell you, look, you got to go get this and amend it.
yeah. Well, and being a computer engineering guy, Patrick, and maybe being having a interesting software, and I had a background in programming kind of and did always did that as sort of a hobby and built a lot of websites and wanted things to work like code. You have to be at peace, especially in state court in Texas, that the courts are not as formulaic as maybe computer code. So
Oh my goodness, yes. And that, that did give me pause at the beginning because I do not like blanks in the forms, right? Like, what am I supposed to put here? I'll just leave that blank. No,
yeah.
not leaving it
Right.
blank.
There's a mentally that's hard for guys like us to get over. But all right,
Yeah.
let's move on to our next legal question. And this one is, how are receivers appointed and what role do they have in judgment collections? Any experience with receivers so far at the firm, Patrick?
No, I don't. And I was actually really looking forward to this because one of the things that a lot of what we focus on initially is how do I sue this guy? How do I
Mm,
force them to come to court, or what can I do to get my money back? And sometimes the answer is, well, we can get you a judgment, and maybe that helps, maybe it doesn't. So people really need to understand what you can do after you get the judgment. If
well,
they decide to pack up and move to Bhutan or something, what are you going to do?
yeah. The, ju-
So this is very good information to
Yeah,
have.
judgment collections that's where the money is. I mean, that's what's important. I once had an
Mhm.
old judge, try to tell a client like, "Hey, I don't have a magic cash register behind the bench here. I've got a pen and I can sign an order and I can put an amount on it, but there's no money back here. You gotta go get your own collections." And we do that kind of work. People often call us to collect on their judgments, and receivership is sometimes is an appropriate part of that process.
Mhm.
Most of this emanates from the Texas Civil Practice and Remedies Code. You've got the turnover statute, that's section 31.002. This is the main vehicle for post-judgment receiverships. And what it does, if you're a judgment creditor, that basically probably you were a plaintiff, you want a judgment. It allows the court to sign an order saying, "Hey, turn over the non-exempt property." There's exempt and non-exempt property. The exempt
Right,
property in Texas is vast, right? You get homestead
right,
and cars and personal property. Most people out there, most regular people don't have a lot of property beyond their exempt property. Non-exempt property, that's things like rental properties, and if you own speedboats, luxury items, whatever,
right.
then you're or cash sitting in a bank account. Cash sitting in a bank
Mhm.
account, it is non-exempt property. So, now if for cash in a bank account, the more appropriate remedy may be a writ of garnishment, but usually we're talking about some type of personal or real property here. If the court finds that the debtor has non-exempt property, and it can't be readily sort of attached or levied by the ordinary legal process, which would be like a writ of garnishment, maybe.
Right.
Then the court can order the debtor to turn it over, or the court can appoint a receiver. And oftentimes you'll see receivers appointed, and their job is to, hey, get the property and sell it under authority. So, and then you get into sort of, there's another section, a code section, section 64.001 of also the Civil Practices and Remedies Code. And that talks more about receiverships broadly outside of the turnover statute. And you have a general kind of catch-all and equity power to appoint receivers, which just says under the rules of equity. Anytime, Patrick, as I think a lawyer reads the rules of equity, you could think that you can just start arguing from,
Right.
or that's your cue to argue policy. If you are ever in debate, just say something good. Anytime you see equity, that's what I tell young lawyers. But the other things besides, there's a kind of a list of I don't know, 7 or 8 things. Equity's one of them. And then you've got other stuff in that list. You can, if there's a creditor, if you're a creditor and you need to fund the creditor's claim, that's another one. Or application if for a corporation may be insolvent. There's several of them under there to get this stuff. And it's a great process. Receiverships are a powerful tool for collecting judgments. To get them appointed, if you need to get a receiver appointed, you got to file a motion or an application filed with the court and ask the judge to do it. There needs to be an affidavit saying, hey, I've got a judgment, it's unpaid, and you've got to swear that the debtor's got some non-exempt assets. And the ordinary stuff is just not practical. So that's why you need a receiver. Probably will have a hearing. You got to get out a notice of hearing, and the debtor needs an opportunity to be heard. I mean, the debtor may file a response to your motion that says, hey, I don't have any non-exempt property. I'm just sitting over in my homestead.
Right.
So, and the court will
And
decide.
that does raise the question too. Like it says, you have to file this affidavit that says the debtor has non-exempt assets. It doesn't really specify how much detail you have to go into. But it could be saying like, I'm pretty sure that guy has a second truck.
Yeah.
But you don't need the VIN number or anything like that. Or you don't,
it can be,
you don't even have to know that it's a green Chevy or, or whatever.
I don't know. The plaintiff could say, hey, I've seen this guy on the lake and he's driving a speedboat around, or could say, I've looked up the real property records and I see he's got 3 rental properties, or he's got 4 properties in Harris County. And Judge, we know you can only have 1 homestead. So those other properties must be non-exempt. So, the affidavit. And then the judge is going to sign an order. He's going to name a receiver, specify the powers and the duties of the receiver. And he'll order the debtor to cooperate. I mean, that's another important thing. You'll often have judges say like, hey, what do you want me to do this? All I have is a pen. I can order the debtor to do something, but what else do you want me to do? And the typical response, if you represent a creditor, Patrick, is Judge, I'm going to file a contempt hearing and he's violated your order, and we're going to throw him in jail for a contempt, Judge. Judges are generally very reluctant to do that. We had a client one time that he would always bring his wife and his young children. And it was, you don't always represent great people. This guy was not. And despite, Patrick, did you know that bad people can have children too? Did you know that? So
I did know that. Unfortunately, I learned that one pretty early.
Right. So this guy our client was really, he was not, I'm not, not revealing any confidential information, but sometimes we do represent just bad, nefarious people that screw people. And he had judgments against him, and he would always bring his wife and his young kids up there. And it worked on the judge. The judge was like, oh, I don't want to put Mr. So-and-so in jail. The kids, behind the bar, right? And judges are very reluctant to have contempt hearings and put people in jail. Now, sometimes you can upset a judge, and I guess they'll do it. So, sometimes judges can get so frustrated with an attorney, they may hold the attorney in contempt of court. You don't want to be in that position, Patrick. You don't want the judge to.
Yeah, that's That's the nightmare scenario, right? You get thrown
Yeah,
in the clinker, and
yeah.
then you gotta, like, what do you do? Like, I'm sure anybody in that position is like, okay, well, obviously I need to get a new job now, and
I've heard this is sort of an old wives' tale or rumor. I've heard someone told me that if the judge ever you're an officer of the court, if the judge ever threatens to put you in jail for contempt or tries to do it, say, Your Honor, I request to be released on my own personal reconnaissance. That's like magic, the magic words you're supposed to say as an officer of the
right.
court. I don't know if that works or not. The judge may just say that's
I can tell you it works in the Navy, or it used to. It
er,
used to work in the Navy. That we had, we'd go out for leave, and the younger officers would sometimes, go and socialize a little bit, get to know the crew. And, sometimes there was, I'll buy around, you buy around, and that sort of thing, and you can stumble past some military police who may want to offer to escort you home, for example, and you can say, "Oh, no, no, I'm gonna go on my own recognizance," and,
uh,
I have watched a lieutenant that I admired greatly who could not say any other syllables, but the one word he was able to pronounce correctly in that state was recognizance.
okay.
It was amazing,
Yeah,
just amazing.
recognizance. There you go.
Mhm.
Well, that's your Navy story. I would not.
Right.
I get scared of military punishments and Navy punishments. I guess I don't know if they would tie ropes around you and drag you under the ship and scrape you up with the barnacles or not anymore. But that was the
Yeah.
old pirate punishment or something. So
Well, they don't do keel hauling anymore, but bread and water was still a thing.
okay, all right. Well, there you go. But all right, let's move on to our next legal question. This one's, I think, pretty easy. How do you tell if a house or property has been foreclosed on? So, foreclosures, and sometimes you do some real property research. This is a simple thing. We had this question come up. You basically just look at the real property records, and you're searching for a trustee's deed. What happens in the foreclosure process very early on, a substitute trustee will be appointed, and that's normally done under the powers in the deed of trust. And then the substitute trustee ultimately goes and strikes that property off at auction. And after a buyer buys it, who bid on it at the foreclosure sale, the trustee then sells the property and signs a deed over from the trustee over to the successful bidder at the foreclosure auction. So, and then you'll have a deed in the real property records and you'll know there was a foreclosure. Doesn't always mean you can find out the sales price. Oftentimes people will want to know, hey, how much did the guy pay for it? It's at foreclosure. Have you seen this language in deeds before? You may just see $10 and good and other valuable consideration. Have you seen that in deeds before, Patrick?
I have, yes, and actually, that was one of the first questions I had, was that it looked to me like that was some kind of misrepresentation,
Mhm.
but it was explained to me that, nope, there is $10, and the other good and valuable consideration is the rest of the money that we paid,
Right.
the
Just
$170,000.
right. It just sort of sometimes you don't even sometimes the $10 may not even change hands. Is that language has just been
Mm,
recited in Texas for probably 100 years or more. Is just what you typically
mhm.
see. The new forms, by the way, the Westlaw forms we use, I think it just has an other good and valuable consideration. Doesn't include the $10 anymore. But to this day, we still get clients asking or calling up saying, I never, I don't believe the $10 were ever paid. And because of the lack of consideration, the deed fails. And we say,
Yeah.
no, I'm afraid that's just not right. So, um,
Well, didn't it used to, well, I remember it used to be a dollar, so that was inflation going on right
but
there, but,
I
I think
did it used to be a
in the
dollar? I
past,
don't know. Like in 18, like how long have we been doing deeds in Texas? Like the 1800s, it used to
right,
be a dollar.
yeah, it used to be a dollar,
Yeah.
um and I think there are cases out there where the dollar never changed hands, and things got overturned.
We're gonna
I'll have to
have
look
to
that up for next
we're
time
gonna
to
have to
see
ask
what
AI
the
about that case.
yeah.
We're gonna look at that case. We're gonna see if we can find that. But
Well, that will be a great segue into the next, section.
oh yes, yeah. All right, we answered that question. That brings us to our rant and rave section, which is my favorite part of the show. You're a big AI guy. You're a doctor of technology, aren't you, Patrick? So
I do, I'm really excited about this. I'm having a lot of fun with it.
okay, tell us how you've been using AI in your practice.
Well, I've been trying to, I've been keeping the practice use and the sort of hobbyist use, separate, because there are some ethical considerations you have to be mindful of when you're using it, as an attorney, and that's, obviously outside the scope of what we're talking about here. But it can be very helpful to, do things like summarize documents. Someone will send you something here. Take a look at this 100-page contract, and as a starting point, you can run that through a preprocessor, what we might have used to be able to hand to a junior associate or a law clerk or something, and say, "Get me started on this. Point out at least something interesting to start with this process." And then at the end of the day, you still have to go through and put eyes on every page, but the AI can help start that, give you a little head start, knowing that around page 35, there's that one section you really want to focus on and look at, and keep looking for things like that. So it helps with that. It can help polish emails, where there have been times when I needed to respond to a kind of an aggressive opposing counsel, and I want to send in this expletive laden response, and the AI can soften it or change the tone a little bit, something like that. That's been a very interesting way to use it as well.
Okay. Yeah.
But also through searching, I've switched almost entirely now to using Perplexity as a search engine instead of the usual, Google or DuckDuckGo or something like that.
Oh, so
because
Patrick, be careful. We have so many listeners. I think you're moving the market. I think you just caused Google to drop like 10%. It's going. I'm showing
Right.
it's going down right now. Okay.
Yeah, sorry, we forget we have to do this. Do it on a Friday afternoon, so it doesn't affect the market clearing.
Right.
But yeah, they people have also used other, all the AI products, ChatGPT, Gemini, everything. They are replacing ordinary search, and I think that's probably a good thing, because the search engines had become relatively kind of dumb and useless for a lot of things. People now were right before AI, people were searching Reddit instead of the global internet, because they were getting responses from actual humans who had done stuff, instead of SEO optimized, keyword based. I don't have an exact answer. I can't tell you how many times I would click on something and the answer was, "I don't know, but let me tell you about this other thing." Like, how is this the number one result?
Well, I mean,
And the answer is, "I don't know."
that's a
That
whole
can't be
nother
right.
commentary on search engine algorithms. But
Yeah, that's crazy.
by the way, Reddit was not happy about all of their content being scraped by Perplexity and ChatGPT to regurgitate the human answers. So we'll see how that legal landscape continues to develop. Here's one of our attorneys kind of popped this in, who just, I guess he didn't realize that anytime he searched Google now, he's getting the AI overview. And he says, I started using, this is a quote, "I started using it by accident because I didn't realize the top entry in Google was an AI answer until I'd been using it for some time. I'm naturally curious though, so when I figured out you could review the websites that allegedly support the AI answer, I would go to the source to see what it said. I'd say more than half the time, the support for the AI answer doesn't actually support what AI is telling you. So I use it a little bit, but I always go look at the source." What do you think, Patrick? Agree or disagree?
Yeah, absolutely. That is absolutely the case. And, so I had formed the habit of ignoring the first result anyway, because it was usually sponsored.
Yeah.
So I was, I'm trained now to look and see anything they're going to put at the top of the page is for them to make money off of, and not to actually answer my question. But I have looked at it, and I would read things and they would be contradictions. It would say, "Oh yes, A is A," and then it'd give a little cite, but also people say that A is not A, and then be another little cite for that. And
Okay.
so that has absolutely been my experience with this too. And I also wanted to click on those links specifically because I'm sure you remember one of the podcasts you did within the last couple of weeks was talking about how the scraping stole the clicks from the actual creators. And so I heard that and had not considered that before. And now I'm trying to make sure that I at least click on the results, so that the people who are actually doing the thinking get the credit for that. Because those are gold for the people,
Well,
actually putting the effort in.
this has affected our firm in a big way. We've lost about 20 to 30% of organic traffic because at the core of,
Wow.
we are a legal publisher. So now there's been other benefits as well. Our CPA, our cost per acquisition on some of our paid search, has gone way down because of advancements in AI. But this is killing publishers. So, and in fact, there's a theory that the internet's going to get really stupid because you're going to disincentivize all the publishers to create content. But
Right.
I think the AI overview is mostly accurate. So I don't. That's been my experience. You and this other gentleman are saying maybe that not so much. I've really taken some deep dives on trying to use it to crunch data. I'm a big data guy. I run the firm and some of my other companies on spreadsheets, and I'm trying to get. Now I'm only using the $20 or $30 per month version of ChatGPT. So maybe if you were to
Mhm.
pay more, it gets better. But I'm having ChatGPT go back and kind of pour over CSV files, and that's where I think the hallucination is occurring. I'm not seeing so much hallucination in some of these simple searches like, tell me, what plant grows best in the month of May in Dallas. I
Right.
think it's getting a little bit better at that, where it was struggling with that 12 months ago, where it might just make up something. I'm seeing it hallucinate things in the data to justify our response. So that's where I think we're kind of hitting a limit. But I mean, AI is big. Everybody's talking about AI. We're certainly
Mhm.
early adopters of it at our law firm, Patrick. I mean, as you know, we push ChatGPT, Gemini. We like the attorneys to use it. We're
Right.
demoing this Friday. We're demoing the Lexis AI product.
Yeah.
Were you there for the Westlaw AI demo?
I did not see the Whistler. Oh, no, I was there for the one, but it was more like you were demoing it.
Yeah.
So we were kind of like exploring it together. But I
Yes.
think the Lexus one is going to be
Th-
the Lexus people
That's
themselves.
right.
Like, yeah.
We're
So
so
this will be like, they'll have the balloons and clowns and the whole
They gotta
thing.
bring the whole thing. Well, look, hey, I was could have pulled out the balloons, but when I did the Westlaw AI demo, which may have not been fair to Westlaw, fair warning. What did you think of the Westlaw AI demo? Was it, where you could type in kind of a perplexity type search or a chat GPT type natural language search? Were you
Mhm.
blown away by the Westlaw results? Did you think this was amazingly helpful or not so much?
Okay, so the advantage to Perplexity or Gab or any of those is that they will do things very quickly,
Mm,
but they have this massive corpus and there's the potential for hallucination. And so the selling point that my understanding was for Westlaw
mm,
was that it would be much, much more accurate on a smaller corpus. They
mm,
were only going to use actual cases. So it was impossible to come up with a fake case.
mm,
And I would have thought that would have made it much, much faster
mhm.
to give the response. But in our testing, we we didn't actually did we ever get an answer to the first one? Did it ever
Yeah,
populate?
yeah. So it takes about 7 to 10 minutes. I mean, is what they advertise. I mean, it eventually does populate. If you're a lawyer out there like we are, and you're thinking about, do I want to pay all this money for the Westlaw AI demo? Know that you need to run the natural language search, minimize that window, work on something else, and then go back to it. I think that's where we
Yeah.
landed. But
Well, I will say though that I have, in law school before AI, the Lexis people and the Westlaw people, they came out there and told us how to think like their search people uh, design the databases. And if you can do with that, if you get used to that, it can be incredibly powerful, much better than just natural language searching. But if you're not doing that, and one of the things that AI has taken that taken away is that skill set to
mm,
practice doing, noun W/2 verb, that kind of thing. When people are just now typing, "Hey, I want to find out how long do I have to file this response."
mm,
And if you're not used to the way that they want you to search, it can be really frustrating.
you know,
But so if this converts in the natural language search that you want to do into an appropriate and efficient search, the way they have their databases set up, it could be really amazing.
yeah.
And
Well,
that's kind of what I'm expecting to see
Well
with Lexus.
well, I'm gonna ask it in a practical business owner kinda way, and you may not be able to answer this. Let's say you were a solo practitioner, it was your firm, okay? And let's
Mhm,
say you had to pay 4 or $500 a month for what they call the Westlaw Classic now.
mhm.
And they said, "All right, Mr. Caldwell, you can have the AI search for, let's say, $1,000." Would you pay the extra $500 a month for it?
Absolutely not.
Oh, man, I
I
think.
mean, that's easy.
Oh, really? Okay. All right. There you
Well,
have
no,
it.
because I've already paid well, first of all, as a solo practitioner, we should mention that in Texas anyway, the state bar does a great job of providing access to cases. And if you're just, if you're just doing basic case research. There are a lot of options out there as a solo. But if you talk to Westlaw, they can get you a deal for solos, and they will work with you for that kind of thing. But $1,000 a month, it should be. I should be able to type in a couple of facts on my legal question, and it'll spit out pleadings for me for
Okay.
that.
All right. Well,
Right?
I don't know if it's there yet. So that's
Mhm,
interesting because they want to charge us a lot more money than that. And I think our firm is kind of sizable now. I mean, I think we have about 20 lawyers last time I checked. So this
mhm,
is a big, when you're at a kind of a large, not that we're this gigantic firm, but when you get larger, sometimes it's easier to, all the attorneys at our firm, it's not their money. I'm the only owner of the firm. So they're kind of like, oh yeah,
right.
let's get it. This is awesome. But then I like to ask the question from the perspective, let's say this were your money, would you spend it? So
Well, I'm not even sure if I had a rich uncle that I would ask him to buy it either at this
okay.
point.
Okay.
I don't think I'm gonna use it. I find myself using Westlaw a lot less, and, one of the things I'm gonna ask the Lexis people is, can you eliminate the extraneous stuff? I
Mm.
I can't tell you how many times I search for something in Lexis, and I click on it, and I get this or Westlaw, sorry, and I click on it, and I get the screen that says, "This is not part of your package."
Oh,
That drives me
no,
nuts.
no, that's
If it's not part of the package, I don't wanna see
their
it.
whole business model is what they can sell you and then upcharge you. I don't want, that's a whole nother rant and rave section. So
Yeah.
we have to close out the show there. So, but
Yeah, we're supposed to be closing these out, not
But
generating
now,
more rants and
no, but
raves.
this has been fun. All right. That brings our show to a close. I've been your host, Phil Silverman. Patrick Caldwell has been my co host and gracious guest today. Like us, follow us, review us wherever you get your podcasts. And as a reminder, nothing in this show is to be considered legal advice, and this has all been for entertainment purposes only. If you have a legal question, email us at info@silblawfirm.com, info@silblawfirm.com. Tell us you want it publicly answered in the podcast. Everybody have a great weekend.